Yes. I'd just like to start by saying that, you know, the reason that I'm sorry we had to go through the extra hour here, but we had had a conversation before, me and Mike did this, and, you know, in relaying some of that to the school board, I was feeling that perhaps I wasn't getting that exactly accurate, so I didn't want to have that happen again. I was the one that asked you to come, Mr. Graham. We are considering changing our policy at this time, and I thought a good baseline for us would be to answer all the legal questions in front of the public and the board, so that we all can hear from you directly what your legal opinions are concerning this reassignment issue. So one of the issues that have come up, and you know, I think you and I have talked about this before, was is it illegal to pay tuition under our contract for our children to go to another school?
Is it illegal to pay tuition under your contract for children to go to another school?
Yes.
I'm not going to state whether something is legal or illegal. I can talk to you and frame some of the issues that there are with respect to the obligation of the district to fund an education. And that obligation, I believe, is to fund the full cost of an education. More than that, we would have to discuss the reasons for that, I believe, because of your current practice in a session that was attorney-client privilege, confidential conversation. So that's my response to that question.
So as our lawyer, if we were to move ahead, or actually move back to the position that we were in last year with our JCA policy before the introduction of hardship, are you saying that that is within the law, or it's not within the law?
Which part of it? I think we have to be specific.
Well,
let me just say this, because we know that there are a lot of questions, and the Hooksett School District has entered into, and I know you all know this, a long-term tuition agreement with Manchester. The district has the authority, but also the responsibility under that contract to send all its students to Manchester. There are exceptions for students who petition the Hooksett School Board for the permission to attend school elsewhere. That's an exception that's contained in the contract. And who are approved to attend school elsewhere. At the time the contract was negotiated, there were three reasons, I shouldn't say reasons, there were three statutory bases for students to be able to attend school in another district beyond where they would normally be assigned. Those three reasons were, one, special education reasons, because of the special education need that a student had and the inability of the assigned school to meet the needs of the student. The second was manifest educational hardship. And the third was the best interest of the child standard that is determined by the superintendent. At one point in time, there was confusion when the district adopted a policy that created a potentially different standard, if you will, for high school students than either a manifest educational hardship standard, which the district already had in the form of a policy, or the best interest of the child standard, which the district also already had in the form of a policy, as it's required to do. It's required to have both of those policies. So a third policy came into being, and that third policy related to some kind of a, well, the question was it a different standard or wasn't it a different standard? Because it used somewhat different language than manifest educational hardship. It used, I believe, the word manifest hardship, or no, educational hardship, and it didn't use the word manifest.
And you're correct, you didn't use the word hardship.
No, it used hardship. It was the standard, the high school policy that was adopted in November was, I'll pull it out.
Used hardship, yes.
It used the word hardship, but it
It's
didn't,
on-
I don't believe it used the word manifest.
Right.
It just used educational hardship. So manifest is something that's plain and obvious. And there were some questions as to whether or not, having adopted somewhat different language, whether there was a different standard. The board then clarified what that standard was, and clarified the fact that the board had intended to apply manifest educational hardship to the practice of granting permission to attend schools at other than Manchester high schools. Subsequently, the board decided, after our public hearing, as I understand it, that it was going to revoke its high school policy, or it was going to suspend the application of that high school policy, pending further review, and it was going to instead request that all applications for students to attend schools other than Manchester schools would be handled through the best interest of the child standard, and the superintendent developed some excellent criteria with our assistance for determining when that best interest of the child standard was met. And subsequently, I understand, that's the way the district has been operating. That practice that you're currently following is sufficient under the law, sufficient under the contract, and the policies that are in place and that are working, which are the manifest educational hardship policy in case someone isn't satisfied with the superintendent's decision on whether or not a best interest has been established, and the best interest standard, which is an application to the superintendent, ultimately then approved by the school board, is working. I, as your counsel, question whether or not there's a necessity for a separate policy to deal with the high school students that's beyond those policies that are now in place and that are working. Those are the policies that were, if you will, contemplated and required at the time the Manchester contract was executed. They were within the contemplation of the parties at the time the Manchester contract was established. And they provide an avenue for students through the statutory process to go through the mechanism of requesting reassignment from a school to which the district has a contract to send, quote, unquote, all its kids. So I guess what I'm saying is, at the present time, the practice and procedure and the policies that are in place, you know, if you remove the high school from it, if you know, and remove the high school issue from it, and said, we deal with all kids. If a youngster, let's take the Colley Middle School, is at the Colley Middle School and believes that there's a reason why that student should not attend the Colley Middle School, they have the opportunity of going to the superintendent to request a best interest of the child standard to attend another public school. And if they're dissatisfied with the superintendent's decision, they also have the ability then to appeal, not appeal, but to file with the school board for a determination that there's a manifest educational hardship under the standards that have been established by the State Department of Education for proving manifest educational hardship, the school board would hear that decision, and there would be a review process for that manifest educational hardship decision that could be appealed to the State Department of Education. So those are the, and that's not different in Hooksett than it is in any other district in the state, because those requirements are the requirement for a best interest of the child's reassignment policy and a manifest educational hardship policy are both statutory requirements. So they apply to all students, and it doesn't matter whether they are attending Manchester schools that the district assigns kids to or Hooksett schools. And so I guess what I'm saying is you've got you already have in place a full set of policies that provides a relief valve, if you will, for students who, for whatever reason, believe that their attendance at an assigned school will not be beneficial to that student. Those relief valves are the best interest of the child standard and the manifest educational hardship standard. They're in place, they work, they're known to people, you have good standards for how you make those determinations. There's a review process that the board is involved in, and you may have stumbled on to solving your own problem already and not made this so difficult.
Well, let me say, Mr. Graham, that was a very good review, and I agree with everything that you said. The reason that we asked you here is there is interest on this board to examine another policy. And having been one of the people that was critical of the policy in November, I particularly wanted to make sure that we did that with your guidance, so that we didn't get down the road only to find out that we were going to be in legal trouble. There are a lot of issues that have come up even since then regarding our contract, well, our attendance at Manchester. I think that the one thing that you have said, we do have a contract with Manchester. And the Manchester contract does not reference any of the RSAs that we discussed. We've been over this language with a fine-tooth comb. It is at the discretion of the school board on a one-to-one basis. So that is putting in that contract that decision with us 5 people. Being one of those 5 people, I want to make sure that I am on firm legal ground if I have an idea that would be successful and be voted on by the majority of the board. And that's why I asked you to come. And I do appreciate the review, and I think we're all here at Hooksett getting very well educated now about JCA and JCB and manifest hardship and all of those kinds of things. So a question has come up that if we have some proposed policies on the table at this point. One of them would be that a parent could provide a reason to the school board that they wanted their child to go somewhere else, feeling that it was, in the parent's opinion, the best interest for that child to do that. And I guess what my question to you would be, under our current contract with Manchester and New Hampshire law, is that a problem?
I think so.
And could you please explain why?
Because I think that the obligation is to, that was entered with Manchester is to send all of the students from Hooksett to Manchester with the exception of, with certain exceptions, and those exceptions have to have some standards behind them that are, and that's an implied term of the agreement. And I guess what I was saying was that at the time that the agreement was entered, my belief is that if someone would look at this and they would say, look, what would have been the practice in the past, what had been, in addition to that, what had been the what was the framework for reassignment that existed at the time, and would look at that and say that's the framework that needs to be followed. Now,
can I ask you this question, please?
Clearly, the best interest of the child standard before the superintendent is a pretty flexible standard. But that's my advice to the board and my advice to the district is that you are on firm ground if you establish standards for reassignment to schools other than the schools with which you have contracted to send all your kids. And you are not on firm ground if you don't do that.
Okay. And I understand that the current system that we have is on very firm ground, and I would agree that the criteria were very clear, and I'm not saying that it's not working.
Right.
So what I am interested in, though, is some of the concerns that you said about the contract. It's my understanding that a contract has to stand on its own. If you're presented with a legal contract, you do not, or a judge does not interpret the environment unless it was coerced, that document was signed or entered into. In this contract, it says that the sending districts will send all their students there with the exception of those that have petitioned and approved by this board. It does not reference under RSA this or that, or JCA, or manifest hardship, or any of those things. So I guess I'm asking, if you were going into court and somebody started to say, well, at the time, the current practice was this, and then the other lawyer said, but look, your contract clearly states this. And in fact, if you want to talk about some of those things, I have talked to somebody that was involved in this contract that said they didn't put that other language in because they wanted that flexibility to allow children to go out of Manchester based on the will of this board. And that in fact, the intent was clearly what it is here. So I don't see how, because if you're saying that it's the framework that preceded this, that's your perception of what that framework was, and what the law is, that law still remains. It's not referenced in the contract.
What you asked me for was my opinion, and I gave it to you.
Yeah, but I'm not asking you your opinion on how we should proceed here as a board to function. I'm asking you for your legal opinion that if we were to do this, would we face potential litigation?
And I answered that question. And my answer was, you are in firm ground with the way in which you are proceeding now. If you do not have standards, you are not.
So can you state any scenario or reason why we would be likely to litigation if we went to the parent giving their best interest to us as a board agreeing with that petition and granting that petition under the contract, that we might enter into litigation?
Can I state what?
Can you state any reason or scenario that if we were to allow parents...
Mr. Pearl, I am not going to make Manchester's case against the Sixth School Board in public.
I'm not asking you to make Manchester...
That's what you are asking me to do, and I'm not going to do that.
So with our current policies of using JCA and JEC, which is Manifest Educational Hardship, are we in full compliance with our contract with Manchester?
Yeah.
If we continue this the way it is right now and don't add a JCB or any of that, we are in full compliance with our contract with Manchester.
Absolutely.
But isn't it true, Mr. Graham, that JCA doesn't even enter into the contract? Because
neither JCA nor JEC, as you said, are mentioned in the contract. There's no question about it.
right, and you can
But those two statutes, those two policies are required by state statute. So regardless of whether they're in the contract or not, the district has the authority and the responsibility to abide by its statutory obligation to maintain those policies. And to the extent it confines its operation to those policies that are required by statute and operates within that statute, it's on, as I said before, much firmer footing. There's no question.
But isn't it true that a high school, even like Bedford, that owns their own high school, could be using JCA right now to tuition their students out based on the superintendent's belief that the best interest of that child is somewhere else?
That's exactly my point. My point is that those policies allow a relief valve for students and parents when an assignment of a student, for whatever reason, isn't working. And the standard for how that's not working is more flexible under a JCA which I think it's JCA, and I don't have my glasses on, I keep looking. JECs and JCAs keep getting mixed up in my head. But JCA, which is the best interest of the child standard, is much more flexible. And again, you know, we can talk about how that statute came about and some of the things behind it. But the point is, it allows a relief valve for students when their assignment, for whatever reason, isn't working. And it allows it relatively quickly, because a superintendent can respond, doesn't have to have a public hearing. The superintendent can look at that, make that determination, and, you know, hopefully, if, because of the history, and there have been requests, a substantial number of requests, I would imagine, and I don't know, I can look at the superintendent here, has there ever been a request for a best interest of the child removal from either from the elementary schools or from the middle school? So it doesn't happen that often. Go ahead.
And it's my understanding that those three laws, the special needs and the manifest and the best interest, is under the assumption that, I mean, they're there as a valve, safety valve, so that those children who need to go to other schools for any of those three reasons is under the full cost as
Right.
well.
Yes. Yeah.
And can you just speak to a little bit about the partial tuition payment that we are practicing?
I have indicated that our advice has been to districts, and continues to be, that it's an obligation of the district to pay for the full cost of a public education. Period. And, you know, I know that the practice is widespread in New Hampshire. I have indicated that I'm uncomfortable with that practice for a variety of reasons. And to discuss those reasons in great detail, I would prefer to do so in a non-public session.
When the contract was signed, were JCA and JCE, and were they in effect at that time?
I don't know whether JCA and JCE were here, but the statutes that require them were.
Okay.
And if Hooksett didn't have either of those policies, it was supposed to.
Okay.
So I don't know about.
They were on the books.
Well, those two laws were on the books.
Yes.
The Manifest Educational Hardship Statute has been on the books since the 30s.
Okay.
And when it was amended in 2001, I could look that up real quickly, but I think it was amended in 2000. Let me just check, so that I'm accurate about that. I think it was amended in 2001 to add the manifest hardship. It's RSA 193:3, and I believe it was amended in 2001. 193:3. Roman numeral 3. Yes, it was amended in 2001 by Chapter 292 of the legislative session to add the best interest of the child standard, and then that standard was amended one other additional time subsequently, just to add a clarification that the superintendent's decision is final, meaning that it can't be appealed to the State Board of Education or to the school board, but that obviously these parents still have the authority under the manifest hardship statute to proceed under that statute.
Okay.
Yep.
So what I was trying to establish that is when we signed our contract in 2002, these laws were on the books.
Yes.
So my question is, if these laws were on the books, why was it necessary to put that language in the contract that parents could petition this board to allow children to go to another school when under the two policies and laws that you've described, it wouldn't matter if it was in this contract or not, because we don't have any contract with our middle school or anything else, and they can go under that law. So what I'm getting at is, I believe this language was here for a specific reason, which was different from the established law at the time. And I'm asking, you know, why would it be here if it didn't mean something different than the laws that were already established?
I think there were discussions about an awful lot in the terms of that contract. It's a very complicated, complex document. I think that there were efforts on the part of those who were negotiating for the sending districts, including the school board members and myself, to build as much flexibility for the districts as we possibly could. And when there was discussion concerning the obligation to send all students there, some contracts have, there were concerns at the time, for example, with respect to what happens with the rise at that point in time. There were concerns regarding charter schools and what would happen with regard to charter schools. And could a district form a charter school and start sending its students there? And there were, you know, economies of scale that people were looking at, running numbers to try and make certain that the majority of students were going to be able to attend the school in order so that the costs of the capital improvements, et cetera, would be tailored to the size and the number of students that would be attending. So there were, it was a long negotiation. I think those negotiations went on for close to a year. And there was a lot of discussions on a variety of topics. To answer your question, as best I can.
Well, I appreciate that it's a complicated document. I just think that what you said is exactly true. This was put in here and agreed to by both parties to allow flexibility to be overseen by this board as far as reassignment other than the state laws that were in place at the time. And I don't think that we can really draw any other conclusion than that, because it doesn't refer in here to anything else in the environment that was going on at that time. And to me, that Manchester agreed to this contract to let this board decide which students it would approve to petition outside the school. And I'm just looking for any kind of legal ground that collides with that. And I really haven't found any. So we can move on from that. I think we've kind of gone through that pretty much. There were some other questions that had come up that I'd like to just ask you about. We had discussed, and I know you stated your case that you don't prefer our tuition sharing agreement, but at this point it is fact. There were some ideas about providing full tuition for those children that financially couldn't afford to add the additional supplement tuition to go to another school. And I'd just like to get your legal opinion on that, prefacing it by saying I know you don't agree with the idea of tuition sharing.
But it isn't a matter of agreeing with it. It's my advice that you don't do it.
So can you speak specifically to if we were to do it on a needs basis?
Same advice.
Fine.
I have a question. In our current contract with Manchester and in the verbiage that they use case by case, if we are practicing JCA, using JCA and JEC, are we in compliance with our contract with Manchester if we continue what we're doing this year?
I believe so, particularly in view of the fact that you've adopted a set of very thoughtful standards under JCA. You know, I think that those thoughtful standards are a necessary component of JCA.
Now, Mr. Pro keeps speaking about in legal opinion if we go to court. It's my understanding that we would technically be going to court if Manchester said we were in violation. We would be going to the Department of Education. Is that correct?
That is correct.
Okay.
But ultimately, that Department of Education's decision could be appealed.
But with using JEC and JCA, in your legal opinion, at this point in time, and if it changes, so.
Again, as I indicated to you, I think JCA, with the thoughtful standards that you folks have worked on, you know, it's not, those standards make sense for and are applicable to any situation where a student is requesting a reassignment from a school to which they are assigned to another school. And those, you know, having thoughtful standards for how and when a request to attend a school other than the school to which a student is assigned is going to do nothing but assist you in terms of defending the district's decision-making process in choosing whether or not to assign that student, reassign that student to a different school.
Mr. Graham, you've been representing us since we signed the contract. And up until November of last year, or actually any time, have we ever been formally put on notice by Manchester for the practice of reassigning students?
I don't know.
I mean, you've never been involved in it? Okay. And I'm just trying to recap here, and you can't, at this point, you're not willing to share with us any advice as to why we shouldn't tuition share? You don't want to do that in public?
No, I've indicated previously, though, that it's my belief that RSA 189-1A is a compelling statute, and that indicates that it's the responsibility of the district to provide a district expense and education to all pupils through the time they reach high school diploma or graduate, whichever is first. That's pretty convincing language to me. And I believe that is the obligation, and I believe that obligation is carried out in not only Claremont decisions, which talk about constitutionally adequate education at no cost to students, but in a number of other cases, and I believe those cases are persuasive to me that the practice which I've indicated, which I understand is somewhat widespread in the state of New Hampshire, is not a practice that is one that we advise districts to engage in.
I just have one final question, if I may. Putting together the two things that you said, how would you feel about if this board was deciding which students would be petitioned to go to another school, and we were paying the full tuition to that other school under our current contract? Would you still be, what would your opinion be under those circumstances? Because we're trying to look at all the possible combinations of a policy we might come up with, and I'm just trying to get your opinion on that.
A policy that would do something, that would do different, what? To
Let me-
allow any student to go anywhere they wanted to?
Let me explain this.
I don't think a policy that allows any student or parent to dictate where they want to go to school is going to pass muster. Because I don't believe that I just don't believe that's going to pass muster.
Well, let me just give you a scenario then. If parent approaches the board, and the board has a policy in place that says the parent shall provide a reason that they want to go to the other school, the board approves them going to the other school under the provisions of the contract, one at a time, and pays the full tuition. That's what I'm trying to get at.
I understand that. I think I've indicated. I told you that my opinion regarding, I told you that following the policies that exist, which are policies JCA and JEC, and applying standards that are thoughtful standards for the reasons why a student may need to attend another school, and having a process for making that determination is a process that is defensible, and that other processes are less defensible.
Well, I appreciate that, and I understand that you're trying to go with the law and what's the safest. I guess I'm just trying to find out from you
That's my job.
if you are, if it's the tuition sharing that is the big issue,
No,
or it is the child going out of the district.
I think they're two completely separate issues. Two completely separate issues.
Right, so what I'm saying is if we took over the full tuition payment, you're saying you're still not in favor of that practice? Is that what you're saying?
I don't have a vote on the board,
Well, no,
it's not a matter of favor of it, it's a question of what my legal opinion is. So I'm just being careful with my own words, which you asked me to be. You know, and I don't, it's not for me to decide, it's for me to try and advise what I believe in the face of lots of laws, lots of decisions, and 28 years of experience are the most prudent things to do in the face of a complex situation. And that's all I'm trying to do. And I hope you understand the difficulty.
I certainly understand that, Mr. Mayor. I guess a couple of things that strike me is that you said that this is a widespread practice in New Hampshire, and after I've looked into it, it really is. And I'm elected here to serve the public. And I am trying to come up with a policy that balances what the public wants with what is responsible for the district. And I have not seen schools being sued over this or going to the State Board of Ed, and we haven't. And so that's why I'm looking for what that level of risk is, because I am seeing so many other schools doing it, and it is kind of a will here that we have some flexibility, and frankly, that will has been growing, and we're trying to deal with it as a policy. So I understand you're going to the best possible option. What I'm trying to get a little feel for is, what if we're somewhere in the middle? Are there some legal pitfalls that we should be looking for? That's what I'm trying to ask.
Yes, and I think I spelled those out.
Well, if you feel that, yeah, that's fine.
I think
Okay.
I think that there are legal pitfalls, and I think I've spelled those out. If I haven't,
Well, I guess, is there any case law or precedents that these have been, I mean, that's one of the things I'm kind of.
not to my
looking for.
knowledge. No.
Okay.
No.
Because, I mean, those would be indicators that that's a bad way to go if case
Oh.
after case have been going down or something.
No question about it.
Okay.
No.
I'm all set, Tricia, I think.
Just so I understand, the JEC is manifest educational hardship. The manifest education, the manifest word, that's what determines the standard. So we couldn't use that policy but add what Dr. Littlefield was using as standards, right? We couldn't say if we just wanted to use JEC,
The manifest
the
educational
manifest
hardship.
educational hardship, and utilize his list of criteria as to what meets that, rather than coming up with a whole fourth policy. Just trying to streamline more. I'm wondering if that's why we came up with the fourth policy.
I guess I want to make sure I understand the question.
My understanding is manifest educational hardship is supposed to be a very tough standard. And part of the criticism
It is
is that we didn't really have any criteria for that.
Mhm.
And Dr. Littlefield has come up with some criteria that he's using under the JCA,
The best interest
the
of the
best
child.
interest of the child,
Yeah.
which seems to be very good standards. Couldn't we just use those standards under, if somebody approaches us under JEC, instead of making a fourth, what I'm getting at is, if maybe we really don't need that fourth policy, if these are in place.
Well, I've indicated that I don't believe that there's a necessity for the fourth policy right now, because you've got a policy under JEC to provide best interest of the child with some clear standards that have been developed after a lot of thought and input from the board and from a lot of people about what that best interest of the child standard should mean and what it means and how it can be flexible but yet provide.
The JCA is for the superintendent, correct, to make
Yeah.
those decisions?
The superintendent makes those decisions, correct. If you make a policy that the board is doing that under the manifest educational hardship standard, I would be somewhat concerned about changing from the ability of the district to do it to the right of an individual to attend somewhere else. And that's the difference. Under policy, under manifest educational hardship, if an individual establishes the manifest educational hardship, they have a right to go somewhere else. And the state board will reassign the student if the district doesn't. So to create a policy that doesn't have detailed and high standards could present difficulties for the district down the road. Does that make sense?
Because I want to make sure I understand this myself. What we've called locally JCB is a policy that's not required.
Correct.
If the board should deny a placement, if the board should deny a placement under JCB, can I overrule the board under the best interest statute?
If the board denied,
Under JCB, whatever that might look like in the end.
and I just want to make sure that I got them all right, because I've got a bunch of policies in front of me.
Okay, this is the old one, and this is the one that we revised November 1st of 2011.
JCB being the high school assignment of students to high
Yeah,
schools?
my question is really quite simple.
Yeah,
I shouldn't
okay.
be using the J's
Yeah.
because if the board were to adopt a separate policy on high school assignment,
Yeah?
which might be atypical for school districts, but certainly within towns. And under that policy, no matter what the standard is, they deny the parental request. Could not that decision of the board be overruled by the superintendent under JCA, which is the statutory best interest
I would
statute?
say that the decision wouldn't be overruled. I would say that the decision would be supported, but for another reason, the relief had been requested because it was petitioned under another provision that allowed for the relief to be given on a different standard. It's slightly different.
What I'm really getting at.
So I don't know that that's an overruling because it's a different standard.
Yeah, it's a bit. What I'm trying to do is.
Come to a different result.
In operating a complex organization like a school district and being fair to the public, I mean, we're confused. I can just imagine what it's like sitting out in the public. It almost seems to me that if the board were to adopt a JCB, and a parent comes in and says, board, under JCB, your high school reassignment policy, I want to send my youngster to Pleasantville High School. And the board says, no, we don't believe that you provided a convincing case. That parent could then come to me and using my statutory authority, I could then say, yes.
That's true. And I agree. I think you can come to a different result. Absolutely. I mean, and again, that's, the reason is that there are different, there are different standards.
Yeah.
Now, they're different standards. And I don't believe, though, that there's an issue with respect to writing JCA, the best interest of the child standard, in such a way that decisions ultimately by the superintendent, which aren't necessarily appeal, but that the superintendent is authorized by the board to make those decisions, and that therefore the board has approved those reassignments prior to the reassignment being made. So if the board has approved JCA and approved the policy for procedures for how it's going to happen, put some parameters on the number of students or whatever the case may be, that could be reassigned, then the board has approved on a petition basis to the school district, right? And the school board, authority to attend another school.
Just to flip that around, so if there was a JCA and a JCB,
Yeah.
and they went to the superintendent first, and he says no, then likewise, the board could take that up and say, yeah, it does meet our standard. I mean, we had this situation last fall, right, where we had really two policies.
Yeah, two different ways of going
So
about
you
it.
could go at it twice if you wanted to, right?
Yeah, with JCB and the manifest hardship too, theoretically.
Right.
Yeah, you're right.
Okay.
I mean, you could have, you could have. And that's what I'm trying to indicate to you at. You know, I would think that there's a lot of, the real thing is you shouldn't be treating the assignment of students to one particular school any different than you treat the assignment of students to any school. It's not just, you've got policies and you've got a district that and a school that is deemed to be maintained by the district because of a long-term tuition agreement. And that's the situation you're in. And for all intents and purposes, it's that deemed to be maintained by the district means that Manchester is a school to which you assign your students. In the same way that a district that has multiple elementary schools assigns half of its kids, the same way the same way Hooksett currently assigns some of its kids to West and some of its kids to Memorial. So that's an assignment that is decided based on geography, and that's the way the assignment works. Currently, there aren't that many large districts, obviously, in the state of New Hampshire that have multiple schools, but oftentimes the reassignment of students that takes place under policy JCA happens as a result of a student being assigned to, say, XYZ elementary school, and mom and dad moved to the other side of town, but he was through XYZ elementary school up until that point in time, and he wants to stay at XYZ elementary school and through the 5th grade, because that's where the kid's been going. But they just moved across town and they want to go there, so there's a reassignment, and it's in the best interest of the youngster to go there. Well, the assignment of pupils has always been fraught. Reassignment issues become, I don't need to tell you, huge issues when we rejigger the lines so that the right number of kids are going to the right school.
So I have a question. So in our current high school maintenance agreement with Manchester, where it's on a case-by-case basis, would we continue to be in compliance with our contract using JCA and JEC, even if there was a dramatic increase in requests, in the best interest of the child to go to a different high school than the high school for
Yeah.
which we are assigned?
Yeah, I believe you are up here. It's not the number of requests. It's the standards that you apply and the policies that you enforce, and you process those through, and it's the procedures that you use in order to follow through on those requests that are important.
Well, I would differ with you on JCA, because there is specific numbers and percentages that have to be dealt with, and then
There
it's
are.
got to come back to the board. So there is a point that the superintendent has to go to the board,
Right.
and the board has to approve it. So the numbers do play into JCA. And just to go back to what you were talking about, I do agree with all the things that you said about reassignment. We don't have those issues of
Yeah.
which school and everything. But I think that the question becomes then, why are these lines in this contract that allow this flexibility? And that's what the public keeps asking. This contract was set to allow this board to have that flexibility in addition to all the law that was already out there at the time. And when I get that question from the public, I read this pretty clearly that it lies here with our decision, and Manchester agreed to that by signing. So I haven't really heard a compelling reason. I know the other two policies work well and they're all the statute and all, but as we said with those two policies, they can work in conjunction, and I don't see why we can't have a third policy and still someone could go for JCA if they wanted to, or they could go to the board. So I'm sorry, I said I was all done, and I'm going to stop there. I can keep going for a long time. So, excuse me. It's okay. Thank you for coming, Mr. Brown. Okay.
Are you going to stay there today?